You know, what happens when a simple neighborhood election just goes completely off the rails? Well, we're about to dive into a case where the winners were announced, everyone went home, and then the results were overturned just days later. And this isn't just some local squabble, it's a full-on legal drama that, believe it or not, ended up hinging on the definition of a single word. So, let's just put the main question right out there. Imagine this. An election happens, the winners are announced, the meeting is over. But then, less than 48 hours later, the board just flips the results and declares totally new winners. The question is, can they even do that? Is that legal? Let's find out.
All right, so picture this. It's March 18th, 2017. We're at the annual meeting for the Desert Ranch Homeowners Association. The big item on the agenda? Electing 2 new board members. Seems totally routine, right? But what happened next was anything but.
It is absolutely wild how fast this all fell apart. So on Saturday, Catherine Overby and Jerome Klinger are the winners. The meeting ends, that's it, right? Nope. Immediately after, a board member, Patrick Rice, starts raising some red flags. By the very next day, a losing candidate emails the board asking for a do-over. And then get this, just 2 days after the vote, the board president emails everyone and says the election is contested and then announces completely new winners, a total 180 in just 48 hours.
And this right here, this is the email that made it all official. See, while one board member had already been talking behind the scenes, this email from the losing candidate, Mr. Schoeffler, formally put the board on notice. It really kicked off the whole investigation that followed. Okay, so with the election now officially contested, the board had to figure out what was really going on. And to their credit, they didn't just take the challenge at face value. They launched their own internal investigation, even bringing in a lawyer to sort through all the ballots and the bylaws.
And what they found? Well, it turns out there really were some serious problems. They met with their attorney and discovered that, yep, duplicate ballots had been counted. An improper proxy vote got thrown in there too. So once they took out all the bad ballots, the result was a tie between one of the original winners, Jerome Klinger, and the challenger, Brian Schoeffler. To break the tie, they held a runoff election about a month later. And this time, Mr. Schoeffler won. So, case closed, right? Ha! Not even close.
This is where our petitioner, a homeowner named Tom Barrs, steps into the picture. He's looking at what the board did, overturning an election after it was called, and he's thinking, no way. They broke their own rules and they broke state law. So he didn't just complain, he filed a formal dispute with the state to challenge the whole thing. Mr. Barrs' case basically had 3 main pillars. First, and this was the big one, he said the board had zero right to investigate the election in the first place, because any objection had to be made during the meeting, not after. Second, he accused them of illegally destroying ballot envelopes. And third, he said they violated open meeting laws by holding these secret, unannounced meetings. So the case goes to an administrative law judge. Both sides make their arguments, and after reviewing everything, the judge comes back with a decision. But it's not the clean win either side was looking for.
Yeah, the result was complicated. The judge found that the petitioner was right about 2 things. The board did violate state law. They destroyed ballot envelopes, and they held improper meetings. But, and this is a huge but, on the most important point, the claim that they illegally overturned the election, the judge actually sided with the HOA. She ruled they had not violated their own bylaw. So, think about that. The petitioner proved the board broke 2 state laws, but he lost on his main argument. For him, this was far from over. That fundamental question, could the board just invalidate an election after it was officially over, was still the whole point. So he asks for a rehearing. And believe it or not, he got one. The rehearing was granted. But this time, the petitioner decided to go all in. He dropped the other 2 issues and decided to focus everything on his main claim. The entire complicated case now came down to how you interpret one single sentence in the HOA's bylaws. So what was it? What was the silver bullet? What was the one sentence that he believed proved without a doubt that the board had acted improperly right from the start?
This is it. Bylaw 2.4. I mean, it seems pretty black and white, right? If you see a problem with the election, you have to say something at the meeting. If you don't, you lose your chance to complain forever. And nobody said a word before the meeting ended.
So here's the petitioner's whole argument, and it's pretty straightforward. Board directors are homeowners too, which makes them members just like everybody else. And if they're members, then this rule applies to them.
Since nobody, including any of the board directors, objected before the meeting was over, the results were final. Game over. You can't challenge it. It's a really solid, logical argument.
And now we get to the final ruling. After hearing this super focused argument, the judge issued her decision. And the entire outcome didn't rest on what happened, but on the precise legal definition of the words in the community's own rulebook. Now, before we get to the verdict, you gotta understand the legal standard here. It's called preponderance of the evidence. It doesn't mean you have to prove your case beyond a reasonable doubt like in a criminal trial. It just means the petitioner had to convince the judge that his claim was more probably true than not. Basically, if the scales tip even slightly in your favor, just 51%, you win.
And here is the aha moment. The judge went back and she read all of the HOA's governing documents, word for word. And what she found was that the documents were incredibly consistent. They always made a clear distinction between a member, which meant any homeowner, and a director, which specifically meant an elected board official. The two words were never ever used like they meant the same thing. And that single distinction changed everything. The judge concluded that Bylaw 2.4, the one that says any member has to object during the meeting, did not apply to directors. The whole investigation started because a director, Mr. Rice, raised concerns right after the meeting. So while the bylaws stopped regular members from objecting late, it said absolutely nothing about what directors could or couldn't do. And this quote from the final decision just hammers it home. The judge basically says the petitioner never proved that a director was barred from raising questions after the meeting. Because he couldn't prove that, he couldn't meet that preponderance of the evidence standard. The board's actions, at least on that central point, were allowed to stand.
And here's one last little twist for you. Remember those other two violations the board was definitely guilty of? Destroying records and holding secret meetings? Well, because the petitioner dropped those issues in the rehearing to focus only on the election result, the final order assessed 0 penalties. Nothing.
So what's the big lesson here? It's that in the world of bylaws, contracts, and legal fights, words matter a lot. The entire outcome of this huge, year-long battle all came down to the tiny but crucial difference between the word member and the word director.
And that really brings us to the final question, the one for you. This whole mess started in a totally normal neighborhood governed by a set of rules most people probably never even read. It's just a powerful reminder that the fine print really, really matters. So it makes you wonder, doesn't it? How well do you know the bylaws that govern your community?